Let's be very clear from the start. This is not a story about a personal dispute. This is a forensic breakdown of a systemic failure. We are going to walk through, piece by piece, how public authorities can use your own data to build a case against you, and then use their own procedures to make damn sure you can never challenge it.
So it begins here. Public bodies, the police, the council, submit records, witness statements, and logs to a court as undeniable fact. They used this data to secure a court order against a man named Joseph Janes, an Army veteran with diagnosed PTSD. The data, you see, was their weapon.
But here's the twist. When that same man makes a perfectly legal request for the very same data being used against him, what happens? He hits a wall of silence. Suddenly, the evidence is unavailable. The weapon is now hidden from view.
And the official excuses? Oh, they're classics. The data was suddenly too expensive to find. Or, get this, no record was held of the information they just used in court. Or the request was manifestly excessive. And this really brings up a critical question, right? If the state can weaponize your data and then just make it disappear, what's to stop them from doing it to absolutely anyone?
The operation against Joseph Janes wasn't the work of one rogue agency. No, this was a multi-agency effort. The key players were Surrey Police, Runnymede Borough Council, and his housing provider, Metropolitan Thames Valley Housing. And together, they created what you can only call a hall of mirrors, a system perfectly designed to make accountability impossible.
Okay, look at this. It's a blatant contradiction. On one hand, Surrey Police tells Janes flat out, no CCTV footage of a key incident exists. But then you look at their own court filings, and their officer's testimony explicitly says they relied on viewing that exact same footage. So one set of facts for the court and a completely different set for the citizen. How does that work?
And you see the exact same pattern with these crucial multi-agency meetings. Now, these meetings were held specifically to coordinate the strategy against Janes. But when he asked for the minutes, each agency claimed another one held the records. The police pointed to the council pointed to the housing provider. The records were everywhere and nowhere, all at the same time.
You have to understand, this wasn't some clerical error. It wasn't an accident. It was a tactic. It's a system designed to ensure no single body can ever be held responsible for the collective action. Accountability was deliberately engineered to vanish right between the cracks.
Now, this whole shell game, this coordinated evasion, it all hinges on a deliberate misreading of the law. Data law can seem really complex, but on the question of who is responsible, UK GDPR is actually incredibly simple. It all boils down to one specific role.
It's called the data controller. Think of them as the boss. They're the organization that decides why data is being collected and how it's going to be used. And because they're in charge, they hold all the legal responsibility. Simple as that. And then you have the data processor. They just follow orders. They're a third party, like a contractor, acting on the controller's instructions. They don't make the big decisions, so they don't hold the primary responsibility.
And right here, this is the lie. In this case, you had multiple agencies, the police, the council, the housing provider, all trying to claim they were just processors for each other. But wait a minute, they were all making their own independent decisions. They can't all be just following orders. This isn't a simple mistake, it's a legal fiction, a story they told to evade liability.
So now we get to the very heart of the machine. The legal processes, the ones that are supposed to give you a right to challenge, a right to see your own information, they were flipped on their head. They were used as tools of obstruction.
This just illustrates the bureaucratic trap perfectly. You submit a subject access request for your data. Step 2, it's ignored for months, blowing past all the legal deadlines. Step 3, it's just closed. No explanation given. And step 4, absolutely no data is provided. You're left completely exhausted and with no answers.
This email from a Surrey Police antisocial behavior specialist, well, it's incredibly revealing. Janes was explicitly warned not to go gather his own evidence by, say, talking to his neighbors. He was told he had to go through official channels, the very same channels that were being systematically blocked and shut down.
This is exactly what obstruction by procedure looks like. It is a deliberate strategy. It's designed to wear you down, to exhaust your resources, your spirit, and your ability to fight back, all while the institution protects itself from any kind of real scrutiny.
And this isn't just about abstract paperwork and legal arguments. This procedural abuse has a devastating, real-world impact. This is what happens when the very system that's supposed to protect you decides to target you instead.
For Joseph Janes, the consequences were catastrophic. He lost his home, evicted, based on evidence he was never even allowed to see, let alone challenge. He was forced into homelessness, literally living in his car. His diagnosed PTSD was, unsurprisingly, severely aggravated. A vulnerable veteran was targeted by the state, not safeguarded by it.
But this is perhaps the single most chilling action in the entire case. Jane's key defense witness, the only person there to testify on his behalf, was physically detained by Surrey police, and they did it under the Mental Health Act, outside the courthouse, literally minutes before she was scheduled to give evidence. In that moment, a fair hearing became impossible.
So, let's be absolutely clear about this. The actions taken by these public bodies weren't just unethical. They weren't just a failure of policy. They were, by any reasonable definition, unlawful.
Look, this was not a series of isolated mistakes. This was a pattern of non-compliance. The right of access under UK GDPR's Article 15, systematically denied. The duty for lawful processing under the Data Protection Act, completely ignored. The duty of transparency under the Freedom of Information Act, it was abandoned, all to conceal their actions.
This was a conscious, multi-agency decision to operate outside the legal frameworks that are supposed to govern their every move. What you're seeing is a fundamental breakdown in the rule of law.
Which leaves us with one final, uncomfortable question. If public bodies can use data to act against someone, but then deny you that very same data when you ask them to account for it, who is actually in control here? And more importantly, what happens to the next person they target?